NACDL is the association of the nation's criminal defense bar.
Well, I'm so glad to be the moderator for this session, and I'm really looking forward to hearing from today's speakers. Before we begin, I'm going to take 5 minutes to provide 2 pieces of context that I think will feel useful for framing today's discussion. And to do that, I'm going to use a few slides. And if you attended yesterday's session, this will be a little familiar, but this is for the folks who are joining us for the first time today. So the first piece of context is that our speakers are going to be talking to us about the stages of the jury selection process and who gets excluded at each of those stages. So as context for that discussion, wanted to outline the stages of jury selection. So first, there are the non-public stages of jury selection. These are executed by the jury clerk or the jury commissioner at the direction of the chief judge or sometimes a committee of judges. These non-public stages don't always occur in the same order, but they always include first, the selection of source lists from state agencies to use as the source for juror names. So for example, a state might get the list of registered voters from the State Board of Elections and the list of taxpayers from the state tax agency and use those as the source for juror names. There is also a stage where the jury officials remove people from the source lists who don't meet the eligibility criteria for jury service. So for example, many jurisdictions set by statute the eligibility requirements and remove people from the jury system if they have a felony conviction. And shortly we'll be hearing from Professor Banal about that particular exclusion. Jurisdictions also exclude people as ineligible for jury service on the grounds that they have insufficient English language proficiency to serve as jurors. And we'll be hearing from Professor Gonzalez-Rose about the scope and impact of that exclusion. Next, using this smaller list of people who are deemed qualified to serve as jurors, the jury office summons potential jurors. It sends out jury notices to the address that it has in the system. And at the next stage, the jury office processes the responses or lack of responses that it gets to those summons. And those responses can include a request to be excused from jury service, often on the grounds that the person can't afford to take off work to serve as a juror. Sometimes it's just a request to defer the date of service. Some people don't respond. And in every jurisdiction, a number of jury summons are returned as undeliverable by the post office because the address is out of date. These non-public stages of jury selection produce a group of people who arrive at the courthouse on a given day prepared to serve as jurors. Some jurisdictions call this a veneer, but everyone seems to use different vocabulary, so it's not always a veneer. But it's at this point that the more public stages of jury selection unfold. They're more public in that they're taking place in the courtroom in front of the judge, the lawyers, and the parties as a part of the voir dire process. And today, Professors Grasso and O'Brien will be discussing some of the challenges and opportunities of this public stage of jury selection, the voir dire process. In this stage, jurors can be removed for cause, which is where one of the lawyers argues that the juror cannot be fair, the judge agrees, and the judge excludes that juror. And finally, there's a stage where jurors are removed through peremptory strikes. So this is where lawyers decide to exclude some potential jurors on the grounds that they wouldn't be a good juror for their case. And then when all these stages of jury selection are completed, we have the actual trial jury that will decide a case. Now, for the second bit of context, our speakers are going to be discussing the legal requirements for jury selection, how to enforce those requirements, and how some of those requirements might need to be changed. So here's a quick overview of the legal context for jury selection. So first, there's a constitutional right under the 14th and 5th Amendments to equal protection of the law, which means we have a right to a jury selection process that's free from discrimination. This right applies in both civil and criminal cases. It applies in federal and state courts, and the right can be enforced by the parties or would-be jurors. And importantly, the right extends to every stage of the jury selection process, which means every stage of the process has to be free from discrimination. There's also a constitutional right under the Sixth Amendment to a jury selected from a fair cross-section of the community. So this imposes an affirmative obligation on the state to produce a jury system that reflects the diversity of that community. This right applies to all criminal defendants in federal and state court, and it can be enforced only by criminal defendants. The fair cross-section right extends to each stage of jury selection up to and including the veneer, all those non-public stages, but it doesn't apply to the voir dire process. And then finally, in federal courts, there's a statute, the Jury Selection and Service Act of 1968, the JSSA, that applies both of these rights, the right to a process free from discrimination and the fair cross-section right, to all federal cases, so all civil and criminal trials in federal court. And the key takeaway from this combination of constitutional and statutory rights is that there are two legal requirements. One, that the jury selection process must be free from discrimination, and two, that the jury system must include a fair cross-section of the community. Okay, so with that context in mind, I'd like to turn to the speakers. And I wanted to start by talking about some of the problems associated with the exclusion of potential jurors. So these exclusions that occur in those non-public stages of jury selection. So Professor Gonzalez-Rose, could you begin by describing the eligibility requirements that are related to language proficiency and tell us about who gets excluded, what's the scale of that exclusion, why the exclusion is so problematic, and what it means for jury diversity?
Absolutely. Thank you for that. And thank you for that overview. I think all panels should start out with orienting here with the governing law and principles. So that was really helpful. So often overlooked is how particularly people of color who are citizens and age eligible to serve on a jury are excluded based upon English language juror prerequisites. And this has been estimated to impact about 13 million US citizens, 11 million of whom are people of color. And so this can happen in a variety of ways. You talked about the JSSA, that also includes an English language requirement in the federal courts. In the state courts, most state courts have English language juror requirements, and they really vary in stringency. Some require only that the juror be able to speak English or understand English. Others require higher levels of proficiency, such as abilities to write and read in English as well. And these are also enforced in different manners. Sometimes there is a more lenient standard on the books, but then in materials such as the website or any pamphlets to prospective jurors, they'll impose a more strict, such as having to be able to write in English. And this can be very, very problematic, excluding people of color. And one example that I think is pretty extreme is the U.S. District Court for the District of Puerto Rico, where it's estimated that 90% of the population is excluded from jury service because of the English language requirement. So that's just a brief overview, and there are a lot of implications there. And I'll just note one last thing is that people sometimes, and I don't think enough, look at felon disenfranchisement from juries, but juror language disenfranchisement excludes similar numbers, and we should also look to that as very problematic.
Great, thank you for that overview. And yeah, I want to turn to Professor Bernal and ask about the felon exclusion rules. Can you address the eligibility requirements that apply to people with criminal convictions, and similarly sort of tell us something about the scope of those exclusions and the impact they have on jury diversity?
Absolutely. Thank you, Nina. So when we think about marginalization, in particular civic marginalization with respect to folks with prior criminal histories, a felony conviction, a misdemeanor conviction, what we typically think about are voting restrictions. I would argue, and I think the data bears out, that the restrictions on serving as a juror are far more pervasive and arguably more severe in their duration. So the current breakdown in the United States, and this is open a little bit to interpretation, I followed Brian Kalt's methodology in his sort of seminal article back in 2003 regarding the exclusion of folks with felony convictions from jury service. And in that methodology, really, we looked at, or he looked at, and I replicated, what did it look like to get your right to serve on a jury back for folks who had prior felony convictions? And if that process was financially cumbersome or time consuming, you needed representation, really what it amounts to then is a permanent exclusion for most folks coming home, right? Coming home after a felony conviction or a serious criminal conviction. So where we stand now, there are 27 states in the federal government who have permanent lifetime exclusions for folks with felony convictions from jury service. In 13 jurisdictions, it is during your sentence, right, during a criminal sentence, which includes any period of supervision to follow a period of confinement. 8 states enforce these types of hybrid restrictions where it depends really on the type of conviction, a term of years that you serve potentially, how long since your criminal conviction, how long since your sentence ended. For instance, Washington, D.C. used to, I believe they're in the process of changing this, used to have a restriction that it was 10 years past the expiration of your sentence. Colorado excludes from from grand juries, not from petty juries. So different types of restrictions that sort of apply in different ways. 2 states allow for lifetime challenges for cause based solely on the fact that you have a felony conviction. And really 1 state, again, according to this methodology, has no restriction at all, and that's Maine. Now, theoretically speaking, Maine doesn't take you to jury service in cuffs if you are currently confined, but on the books, there is not a statute sort of speaking to whether or not someone with a felony conviction can serve as a juror in Maine. Reasons for these restrictions are twofold, generally speaking, that folks with felony convictions supposedly lack character, such that they will impact the function of the jury process, but also maybe the appearance of it, appearance of impropriety if we were to include such citizens. And also the second sort of justification that's relied upon is this inherent bias rationale, the idea that folks with a criminal conviction will unduly sympathize with others who are fighting a criminal case, right? And that they will be adversarial to prosecutorial agents in all instances. I just want to note that these restrictions are categorical. So in all but 4 jurisdictions that impose any type of restriction, they apply to any type of felony conviction and for any type of case, civil or criminal. So while those rationales may make some sort of sense, right, in the criminal context, they certainly, there's more of a challenge in the civil context. So that's a sort of overview of where we stand on that.
Great, thank you. And Professor Grasso and Professor O'Brien, moving now to the more public stages of jury selection, can you describe some of the ways, give us a little overview of the ways that that stage of the process introduces challenges or opportunities for jury diversity?
Shall I start? I'm going to start first. And usually we're sitting together, but COVID makes everything different, doesn't it? So I guess just as a sort of the frame that we're thinking in is voir dire, right? Once we're in the public eye and the attorneys and the judge perhaps are trying to collect information to make decisions about the participation of jurors. And we know from lots of research that race creeps in significant ways in the course of this process. We know that peremptory challenges are struck on the basis of race, and also are beginning to see ways in which race matters in cause strikes. And some of the research that we've been looking at recently has looked at the way voir dire happens. Like, what are choices about the information? So it's not a categorical bar, as Professor Banal just said, but rather it's a way in which participants learn about the potential veneer member.
I obviously agree with all that. If you think about the process of voir dire, it's an information gathering process, and cognitive biases come into play when people are gathering information. I mean, we've all heard of confirmation bias, where you tend to look for information that supports your existing hypothesis and to discount information that doesn't. And the way that can work in voir dire is sort of a form of stereotype maintenance, to the extent that the actors, whether it be the attorneys or the judge, have certain stereotypes about sort of the leanings of particular jurors, their willingness to side with the defense or the prosecution. They may engage in an information gathering exercise in the form of voir dire that will tend to support what they already think to be the case. So they'll ask questions with an answer in mind that then is more likely to elicit that answer, and then it, then that's the basis on which they choose to strike or pass a juror.
It's also making me think, I framed this as Professor Gonzalez-Rose and Professor Banal telling us about exclusions that occur in the non-public stages, but both language fluency and accent or criminal history can show up in the public phases in the context of the for cause or the peremptories. So actually, if I could turn back to each of you, maybe starting with Professor Gonzalez-Rose, about how you see that initial proficiency exclusion sort of echoed or mirrored in the voir dire process.
Absolutely. So I started out talking just about the English language juror requirement, but linguistic disenfranchisement from juries spans all of the type of linguistic usage. First of all, we have people who are limited English proficient. We also have people who are bilingual, and I can talk about that. But we also have people who speak English fluently with what's perceived as a minority accent. And a case that really epitomizes this is US versus Gould in the Supreme Court of Connecticut. And in that case, at the trial level, a gentleman showed up for jury service. And in the selection process, he spoke for over 20 minutes and answered over 100 questions without any problem. Everyone could understand him. But at one point, it was shown in the record that the judge was uncomfortable asking him questions, so English isn't your first language and so forth. And he said no, I'm from Puerto Rico. I've lived in Connecticut for a long time. And the judge said, well, that's fine. But eventually they excused him for cause, not because he couldn't speak English sufficiently, but out of a concern that other jurors could not understand him adequately for deliberations and such, which was very interesting because in that jurisdiction was 40% Latinx with actually 40% Puerto Rican, and with another about 5% of other Latinx. So here, almost half the population in that jurisdiction is Latino. And so wondering who is actually selected for these juries such that they would be so unfamiliar with a Spanish accent, with a Hispanic accent. And so here we're seeing that there's exclusion on the basis of accent, not language, but when it's couched in language terms, then it's allowed to exist. And just one final thing about that, the Court of Appeals found that this was an abuse of discretion, that there was no evidence in the record that this gentleman could not speak English sufficiently to serve as a juror. The Supreme Court of the state affirmed that, and yet it was basically treated as harmless error. It's if he had been excluded because he looked like a racial minority, it would have been fundamental error requiring a new trial, but because he sounded like a racial minority, it was allowed to pass.
Well, and turning to you, Professor Banal, can you also speak to how someone might survive the eligibility requirement at the non-public stage, but then still be excluded because of connections with the criminal justice system at the in voir dire?
Sure. So when I conducted a significant amount of research up in Maine to explore exactly, what does this look like when the eligibility requirements allow for folks with felony convictions to serve? And what I observed in the courtroom was that, during jury selection, the public phase of jury selection, oftentimes when someone answered in the affirmative that they did have a criminal conviction, or the prosecutor was made aware of that by running records prior to jury selection, it was raised and almost always dealt with at sidebar. So it was not done in the presence of the jury for most part. Now in California, and again, this is very limited data because California obviously lifted their restriction on certain folks with felony convictions starting in January 2020. We've looked at a few jury selection transcripts in the state, and it appears as though judges are also conducting an evaluation at sidebar. So it is not sort of as public as it might be for some other characteristic.
And we can add that in our studies of jury selection that we've primarily looked at peremptory strikes, but any sort of contact with the criminal justice system, either by the potential veneer member themselves or by a close friend or family member, was a huge predictor of being struck from the jury by the prosecutor. So even though there was no formal bar to them serving, I mean, it served as a very powerful predictor that they were the same rationale that goes into these restrictions as operating as an assumption about who's a favorable juror at the peremptory strike phase.
Yeah, and what we're seeing in California, again, in a limited sample, is strikes across the board for anyone who preemptorily, anyone who raises, the fact that they have a criminal conviction. So it's pretty standard, and it's not. There really isn't much argument about it.
But it does raise a question about the quality of the voir dire, the quality of the thinking of others. It seems like the kind of stereotype, right, that seems innocent, but we know is not innocent. We know that it has race effects on the diversity of our juries. And also it's sloppy. It's not the case that everyone who has anything to do with the criminal system is on one side or the other of this. So better voir dire that tries to figure out what's important about this person who actually showed up to serve on a jury seems like would be worthwhile to keep thinking about.
Yeah, and with respect to that, if I might, in the work that I conducted in Maine, right, we interviewed judges, trial court judges throughout the state, and it was sort of funny, right? Ironically, a lot really pinpointed a number of factors that they used in common, right, to assess someone who came into the courtroom who had a felony conviction and was eligible to serve. How long since the crime? How close the charged crime to the crime at bar, right? The conviction. Interesting ones that I felt were slightly irrelevant, right? How well has this person rehabilitated, broadly defined, I think. But the factors were relatively consistent, and they were trying, I think, to individualize the process and to really get at whether or not this person was fit apart from a criminal conviction.
Interesting. So my next question is, given both these formal sort of statutory exclusions and the informal ways that people are being excluded through the voir dire process, I'd love to hear from each of you about what is lost. Like I started by saying, well, we know we have these entitlements. We have a right to a process free from discrimination. We have a right to a pool that reflects the community. But sort of above and beyond that, what are we losing when these different populations are being excluded from the juries? So I don't know if it's easier if maybe Professor Gonzalez-Rose, do you mind beginning?
Happy to. So what we're hearing a lot of what is lost is having Black, Indigenous, and other people of color on juries. And that's important because juries are supposed to be a body truly representative of the community. They're supposed to come from a fair cross-section. And what we know is that juries who are more diverse, there's less expressions of racism, there's more checks on implicit bias, and there's more thorough deliberation. And so it's important that we have people of color on juries. And here when we've heard, people with minority accents or perhaps even perceived minority accents, excuse me, or people who have felony convictions or have interfaced with the criminal justice system are disproportionately people of color. And this disproportionality is due to structural racism. And so here we're seeing structural racism replicated from, the stop to the frisk to the arrest and so forth, all the way up into the jury box where criminal defendants who disproportionately are experiencing these things cannot be judged by a fair cross-section of the community. And so we're missing that sort of diversity, and we're missing the promise that we've heard from the Supreme Court, that we have a body truly representative of the community.
Professor Banal, could you speak to that? What are we missing out on?
Right. So apart from, I think, the diversity of experience, I think what we also are missing out on in terms of folks with felony convictions are good jurors, folks who want to be there, right? In the studies that I've conducted and in the limited data that I have, what we see is that folks with convictions want to serve, are interested in serving, show up when called, and that they approach the process thoughtfully and really conscientiously. The lack of character assumption really didn't bear out in the data, nor did the inherent bias. I'll give you a quick example about sort of how experiential knowledge can really enrich a deliberation. We ran a mock jury study, and we had a criminal defendant who was on parole at the time that he was charged with committing a bank robbery, and he had missed an appointment with his parole officer. And in response to that, said, "Well, it looks like I'm going back to jail." And he had made this statement to a witness. Well, many of our quote unquote non-felon jurors saw that as an admission of guilt to the charged crime, right? The bank robbery. It took folks with a felony conviction in the deliberation room to explain, hey, he didn't say that because he admitted to the crime. He said it because he missed an appointment with his parole officer and had contact with the police when they questioned him about the crime. Both of those things, right, put him at jeopardy of going back. That's knowledge that folks who have been on parole have, right? Or folks who study parole or involved in the parole system have. But generally speaking, I would argue, the general public maybe isn't, privy to that. And in that way, right, they may have gone on that admission as an indicator of guilt, right? When in fact, that wasn't the case at all. So I think that there are really skills, right? And factual knowledge that you gain from having gone through the system that really can enrich the deliberation process.
I think that's such a great example of what the panelists yesterday were talking about, right? There's better thinking and better conversations. The research has shown again and again that a diverse group of people does a better job thinking things through. And so aside from just the importance symbolically and practically for our system, it's also going to lead to more accuracy and more fair outcomes if we do a better job at every stage of including as much of our population as is willing to participate.
And also, I mean, we're all aware, I'm sure, that, the use of trials is diminishing, vanishingly small, that there is a tremendous amount of pressure on defendants to plead guilty. We've all heard of the trial penalty. And, here we have the idea is that the trial is a lot of resources, so there's all this pressure on the defendants to plead. So we have this process, when we have voir dire, we want to get something worthwhile out of it. We don't want to just extend the process, make it more resource intensive. If we're all just going on our stereotypes and our gut, our hunches about people, teachers are like this, social workers are like that, people of this race are going to favor this side. And then it's just, I always think of, a poorly done voir dire is just a vanity exercise in vanity. Like you're just kind of out there just trying to confirm your stereotypes about different categories of people. And it happens to be, I think, it happens in all sorts of domains. It's most pernicious and damaging when it comes to racial or ethnic groups. But that's another thing we lose. If we're just, if you're just going to go on your gut based on something, the TV show that juror watches or their racial background or whether their cousin had a run-in with the law, might as well just skip this whole expensive resource-laden process and just pick randomly. But if we're going to do it, we should do it using best practices so we can make the most informed decisions about who should serve.
Well, and that's what I want to turn to next. We've highlighted some of the problems, so I want to shift over to solutions and best practices. But I pausing to take in what you're saying about what we're losing. That we're both losing the perspective of the people who are excluded, and we're lowering the quality of deliberation by the people who are still there. And as the research shows, it's not just that people of color or people with certain life experiences are dropping that into the jury rooms full of knowledge, but that white people are making fewer factual errors and identifying more missing evidence and raising more case facts. And so it's sort of a two-pronged loss when we're excluding communities of color from our jury system and people with different life experiences. Okay, so the good news, the solutions. Professor Gonzalez-Rose, can you share your suggestions for either limiting or eliminating the exclusion of jurors with limited English proficiency? And for each of you, I'm going to ask you as a part of that to identify the objection that you get most commonly to your reform proposal and how you would respond to it.
Excellent. Well, I teach evidence and the objection is money. It's so expensive because I want to talk about juror language accommodation. And that's something that actually has a rich history in the United States. Juror language accommodation is allowing jurors to serve with the assistance of interpreters. And that was a practice that existed in the United States for a long time. And it currently exists in the state court of New Mexico, where jurors of all languages are allowed to serve through interpreters. And the objection there, I think, is primarily just that it costs a lot of money. There have been enough mock jury studies and other social science discourse on this to show that they're accurate. And there has even been some increased interest in serving in a jury again if they serve with a limited English proficient person who had accommodation for so it seems like it's a very positive thing, but it's an investment, right? It's an investment in resources. I think it is attainable, particularly with the use of technology and what we've seen with the ability for interpretation that doesn't have to be in the room. So that's one thing that I think is a real opportunity to be more inclusive. And there's also juror language accommodation in courts for those who are hard of hearing and deaf, who are fluent in American Sign Language.
Great. Okay, so those are two models that we can use. And Professor Bernal, what are your suggestions, again, for limiting or eliminating the sort of varieties of exclusions of people with felony convictions? And again, what's the objection you hear most commonly and how would you respond to it?
Sure. So I like the main model. So let's start with that. No legislation regarding whether someone with a felony conviction can serve or not. But I understand legislative compromise, and I understand that oftentimes reforms in this area are incremental. So I was involved a little bit with the passage of SB 310 in California, which restored juror eligibility to folks with felony convictions, with certain felony convictions. It did carve out folks who were on active supervision are still not eligible to serve, nor are folks with a registrable sexual offense are still excluded for life in California. In going to Sacramento and speaking about my research and working with some folks on SB 310, I did get to hear the objections firsthand, and they were really many of the same objections made in other criminal justice reform areas, right? That folks with convictions are a threat, that they are dangerous. The chief objection was that folks on supervision, if allowed to serve and then violated their supervision during the trial, would disrupt the trial process. To make no mention of alternate jurors, that was the one argument, or anyone else who maybe has some issue during the trial that must be taken off the jury. The second argument, again, fear-based, emotive, was that if we were to allow these people onto juries, we would have to increase security at courthouses. There would be far more people with felony convictions frequenting those places. Even though during testimony, there were no less than 30 to 40 folks with felony convictions in the room advocating for SB 310. So it really emotive, right? Fear-based, and the empirical case against lifting these restrictions doesn't really exist. And so I think that the next move, right, is to move to a motion, and that's what we see in lots of places where reform's been attempted.
Thank you. And Professor O'Brien, you mentioned, it's an exercise in vanity unless you're following best practices. So what are the best practices for voir dire? And what objections do you get when you're recommending that people implement these best practices?
So I should start just by admitting that I don't know if the system I don't know how I feel about peremptory strikes, right? Like I feel, and I realize that if we were to eliminate peremptory strikes, we'd still have the same sort of issues with cause, because you still have to examine the jurors to see if there's a reason that they can't serve. I'm definitely in favor of reducing the number of peremptory strikes. I think that more than a few just turns into, it just multiplies all of the inefficiencies of voir dire. But if we to the extent that we do maintain the current system of peremptory strikes, actually the advice is the same that, you know, most of us received when we took trial advocacy in law school, which is ask open questions, which is really, you know, trial advocacy 101 advice that is remarkably rare that it happens. I think that lawyers are so accustomed to asking questions that they already know the answer to, that asking genuinely open questions that don't suggest what the right answer is. I mean, can you be fair is tells you exactly what you're supposed to say. In our own research, we have found that this makes a difference, that you get better quality information, you get more information, so at least you can make a more educated decision. Catherine, do you have anything to add?
Maybe just one part to that asking an open question and making it clear to the person listening that you do care, right? That it's important, not just from the judge, but from everybody, that it's important to, wait, it says, why would you only eliminate them from one side? She would never eliminate them from one side. She would never take any away from just one side.
I think that was in response to an earlier question in the chat.
I know, I just get worried when people think we're taking away peremptories. So the second thing I would say is that we know that we get better answers when the person asking makes it clear that they're open, not just to any answer, but that they care, that it matters. But I want to back it up a bit. The other reforms that I want are, I think, back to Professor Gonzalez-Rosa's, it costs money. I think research has shown that attorneys should be involved in voir dire, not just judges. That veneer members are better able to respond and more likely to provide more complete information, which they still don't, if attorneys are asking the questions. And also, when appropriate, like the sidebar conversations that Professor Banal mentioned, when appropriate, the voir dire should be individual. It shouldn't be in groups. That when there are conversations that need to be explored more completely, there should be a way to have that conversation and not to have to jump to a conclusion and exclude someone. So those both cost a bit more money. And I think that they're worth the time. I think the research has shown that people who participate in juries are glad they did, right? That even they didn't want to go and they were too busy and the workday was pressing upon them, that once they show up, they warm to the process. And I think voir dire that's done in a way that is less accusatory, in being more open and asking questions that are open and care, will lead to more complete information and will have everybody more confident that there's a fair jury.
Nina, if I might just add to my answer. So one of the other things that comes up when we talk about lifting statutes with respect to folks with felony convictions is this idea of notification, right? Once these statutes are amended, we have to let folks know that they're eligible again, right? Get them back on the jury rolls. And in California, I mean, we looked at this after the passage of SB 310. It was passed in January. We looked at it in August. And really 2/3 of counties had offered no information about this legislative change on their public-facing county websites, where most prospective jurors go to get information. There was no information regarding the legislative change, and some incorrectly stated the legislative change, right? Saying that there were additional requirements when really there weren't any, or just leaving the old statute up and suggesting that folks were still restricted permanently or excluded permanently. So I think that not only is legislation needed, right? I would hope full lifting of these statutes rather than piecemeal, but even in the case of piecemeal, we need to let folks know that they're eligible again, right? Because at least in my research, we see that there's an eagerness among this population to serve. They just don't have the information. So what it turns into is what folks on the voting side have called de facto disenfranchisement. I mean, we sort of have that on the jury side as well. So I just wanted to make that point because I think it's important.
Well, and it parallels the point that Professor Gonzalez-Rose made at the beginning, that sometimes even if there isn't an exclusion on the books, there's more stringent language on the website or the court forums about it that ends up adding or emphasizing exclusion where maybe even the law doesn't demand it. So I have a bunch more questions. I'm also seeing questions from the audience, so I'd like to turn to some of the audience questions. One set of questions is tied to the other components of the jury selection process that contribute to underrepresentation of communities of color. So some people are identifying the problem with source lists that fail to include some of the same groups that we're worried about excluding. Also the role played by the economic burden of jury service. So just open-ended, do you have any thoughts about how the exclusions that you're talking about are focused on connect up to other stages of the jury selection process?
I could just add a small one. One thing that we see happening with English language juror requirements is that people are utilizing those to opt out of jury service. So for instance, it may be more easy to opt out if you have a Spanish surname because of this presumption that someone with a Spanish surname wouldn't be English language proficient. Or if people are asked, it's a very insulting question. We've seen instances where it is predominantly Latinx individuals who are being asked further questions, and they could just easily say, no, okay, Spanish, English isn't good, so I'm going to leave because serving on a jury may not be what people want to do, and there's a legal concern about this because we've seen where people are somewhat voluntarily opting out. That can be a Sixth Amendment violation in itself because it's a systematic exclusion of a population, of a cognizable group. So that can be concerning as well.
Right, so dovetailing there with the role of non-responses or maybe the request for excusal that happened at the court. Do any of our other panelists have thoughts about how different exclusions at different stages of the jury selection process operate together?
I think there's been excellent work documenting how the stages work together. So we know that when jurisdictions fail to update their addresses regularly, not all demographics move as frequently, or when we make it take 2 steps instead of 1 to get to the jury house, or we make it hard to plan ahead, or you don't have a 1 day or 1 jury process, that those kinds of barriers lead to non-participation or exclude people. So I think that I would go to the National Center for State Courts and I would go to the Center for Jury Studies and look at their best practices, which are not controversial. They're clear and they're good strategies, I think, for developing more complete summons practices and helping the on-ramp to get into the courthouse be shorter and clearer. And then also their best practices for how you treat people when they get to the courthouse, right? Is it terrifying to walk in the door? Is there a 10 million gates that you don't think you belong through, or metal detectors? Or is there someone there who says, don't worry, you just have to go through the metal detector and your coffee's on the right? Right, we know that those practices all matter, and I love so many courts around the country, I think, are really trying to do better, and I think it will make a difference.
I mean, I think, related to that, I mean, we're not talking about Batson, but we were touching on it. It just, the experience of people of color in particular who are excluded from jury service. We kind of assume that people are just like, hey, I got out of jury service, and that's probably the case sometimes, but that is deeply insulting. And and if you look at the work, so Equal Justice Initiative does interviewing jurors who've been excluded, I mean, they're painfully aware of what is going on. So it undermines the legitimacy of the system in a way that would make you much less eager to want to take time out of your life and show up and bear whatever costs are associated with that, if you know that you're not going to get a fair hearing out or a fair screening. That just would sort of feed into the whole. I mean, like, I know if I get called for jury service, they're not going to pick me because I'm a law professor who studies jury. So, but that's okay, right? But if I felt like I wasn't going to get picked based on something, as sinister as my race or my ethnicity, it just, I would look for a way to get out of it, right? I would look for an opt out in the system. Why put myself through that? Why put myself through those aggressions?
And just to add on to that, I think that's one of the things that was striking about what I found speaking to folks with felony convictions and their eagerness to serve, right? Exactly what you mentioned, right? It's insulting, right? To show up at the courthouse and then to be categorically told, hey, you can go home, you'll never be called again, and in a pretty public fashion. I mean, some of these eligibility, you didn't fill out the juror questionnaire and brought it with you, you fill it out at the courthouse, right? If you check number 5, raise your hand. And I mean, that's a pretty, I want to just also suggest that some of these other issues regarding show-ups, right? Transportation, financial concerns, loss of a job, right? All of these things are amplified for folks coming out of prison, right? Because they're trying to, and folks with felony convictions, many serve time, right? Come home, they're working through the reentry process. And as part of that, have to find gainful employment after a number of years away, right? Try to find stable housing, try to find stable, reliable transportation. All of these things can be a hindrance when it comes to showing up to jury duty. So I think this is all sort of meshed together, right? And these other structural barriers, I think, impact folks, apart from the legislation that excludes, impact folks this way too.
Thank you. Another question that I'm seeing in the chat is, what promise do juror questionnaires, longer, richer juror questionnaires hold for responding to any of the issues that you've raised?
Well, I can tell you they would make my research a lot easier. if we had more detailed questions, but I don't think that's the primary concern of anyone.
I honestly don't, I don't know research that actually looks exactly at the question of the length of the questionnaire. I'll bet there's some tension between how long it is and how complete it is when it gets turned in, and how much time is provided or assistance is provided in completing. Of course, most of the juries that I've read are capital juries where there are lengthy and excellent questionnaires, but those are rare. Usually it's 2 or 3 questions. So I think the quality of the questionnaire is important, and somewhere there has to be time to have that kind of engagement.
Professor Gonzalez-Rose or Professor Bernal, would having a longer, richer questionnaire help with the exclusion based on language or convictions, or would it just add more obstacles?
I think it could be burdensome, right? I think it could be burdensome. The JSSA says that people have to have English well enough to complete the questionnaire. And if the questionnaire was longer or more in depth, it could be more intimidating to complete. And I don't know about you, but even when I get surveys, I start out enthusiastic, and there's so many I don't finish because I just, and I think I have pretty high tolerance for assessments due to my career, but I think it could be problematic. Maybe there could be another way.
I agree. Oh, sorry.
No, actually, she'd ask you should go first.
I agree. In the types of questions that I can envision being asked with respect to a felony conviction are questions that will take the world of criminal history inquiries on college applications, right, or on job applications. Answering those questions can be re-traumatizing, can be incredibly embarrassing. Or what we see is that in the in college application world, a lot of folks just walk away from the application when they're asked those sorts of questions. So I think that those types of questions, I think, yes, absolutely would be problematic to put on a questionnaire.
And I was just, thinking about, some of the different questionnaires. I've seen different questionnaires, and to the extent that they get longer, and in one ways they could be richer, right? Like you could really delve into people's thoughts and attitudes about things. But that's also just another opportunity for people to sort of test out their pet lay theories about, probably all talk to litigators who have theories about who makes the best jurors, and it's some particular cocktail of like reading habits and media consumption and profession. And I don't know if there's anything to those, right? And so if we're just sort of adding another layer to the process for people to ask questions about, what magazines you read and all that, I mean, there's a place for that, right? But that could end up just becoming sort of a creature of its own.
Well, that highlights for me the point that you're making about jury selection, these public stages, voir dire. lawyers feeling strongly about their own instincts and what their experiences taught them. We're seeing that in the chat as well. I always do this, I never do this, which is separate, of course, from the question of what's demonstrated by the research. So I guess another question I have is there any bit of social science data studies that you did or that you've read about that you wish more people knew about in the jury context?
I mean, I'll lead off. I think that for years, the exclusion of folks with felony convictions from jury service sort of hid in the shadows as the little brother of the other civic marginalization, right? The voting restrictions. And I think are as important. And, I'm just excited that folks are starting to read the literature and sort of looking at, the empirical basis for the rationales, which really doesn't exist. So I just think, generally speaking, the fact that this topic is gaining attention is worthwhile for diversifying our juries.
And I don't want to put you on the spot, Professor Bernal, but is there any of your own research, if I may ask you, like a conclusion that surprised you or that disrupts a myth that you want to highlight? You haven't yet.
Yeah, I mean, when I set out to do this research, what I really used as sort of the impetus for the research was the rationales, right? Why are we doing this? And can I test those? And do they hold water empirically? And in a number of pilot studies, the one I'm most proud of probably is the mock jury experiment, where we included folks with felony convictions. I was surprised, I wasn't surprised to learn that there were really no differences in terms of deliberation quality, but that in fact, folks with convictions could enhance deliberation quality in a number of ways on traditional metrics of, time spoken and number of novel case facts raised, but also when we look at sort of the transcripts qualitatively, some of the other, pieces we dug out as the example of parole that I used earlier. So I was taken aback at the quality, the fact that they enriched rather than just didn't detract, right? And so that was an exciting finding. I also was very surprised that folks really wanted to serve. I've spoken to a lot of formerly incarcerated people and folks with felony convictions in the course of my research, and many just really don't want to be around courthouses and don't want to be around lawyers or any of it, for forever, right? That's a negative experience. The fact that folks really expressed a willingness and an eagerness to serve in Maine, and specifically where they were eligible to serve, caught me off guard completely.
Do any other panelists have data they'd like to share?
Funny, what comes to mind for me, is that I want more transparency and more consistency. So I don't know if I want a uniform code of jury selection. I don't know, that seems a bit much, but does it have to be quite so different everywhere? And most importantly, Barbara and I have called for better data keeping and transparency. So let us see the questionnaires, set up protocols to protect the individual privacy. We don't need to know names of jurors. I hate when they get bandied all over the place. But I want to know, how good were the questions in the questionnaires? How reliable was the conclusion that they drew in the transcript? And usually it's difficult to get a hold of this information, and there are not, every time we look in a new jurisdiction, it's reinventing the wheel. So I think we've written about that. No one ever reads it. So if I could pick one that I'd have jurisdictions all across the country reading, it would be that one.
Yeah, I mean, I was thinking hard about like what research we've done that we want people to read. And I mean, one of the things about a big block of our research is really basic, just looking at how the exercise of peremptory strikes is used, right? That and controlling for so-called race neutral factors, even though some of those are arguably not race neutral, and seeing this very profound racial bias. Particularly, we focus on prosecutorial strikes in the selection of juries. And there's sort of two, I mean, like we can sort of get two opposite reactions depending on the audience. One is like, well, yeah, everybody knows that there's racial discrimination in jury selection. Everybody knows Batson doesn't do what it's supposed to do. Or if it's a different audience, it's a how dare you? How dare you? I am colorblind. All I want's a good juror, right? Like it's like either like, yeah, tell me something I don't know, or this is, you must have fabricated this data because it's so outrageous. But I would second what Catherine said about but be able to do this research, I still think is important to document it, to show the persistence of this. And to do it, it's not that hard to do methodologically. You just got to get the access to the materials, and we measure what we care about. And if we care about jury representativeness and we care about diversity in juries and protecting people's equal protection rights, we should be recording this information. And it can be incredibly hard to get your hands on, which isn't unusual in the criminal justice context, but I find it always frustrating, even though I'm not used to it. I'm still mad every time.
This was one of the points raised in yesterday's session, the difficulty in obtaining data about who is included and excluded in the jury system, and the need for it to enforce one's rights or to assess how well we are representing our communities. I'm seeing a lot of comments in the chat, many about peremptories and most from lawyers. So I want to highlight that tomorrow's session is focused exclusively on Batson and peremptory strikes. So I encourage folks to attend that. But speaking to this audience of lawyers, I mean, of course, there's other people there as well, but what would you say to lawyers who obviously are here, care about this issue? What can they do to help increase jury diversity? And you could think about it either in the context of the case they're litigating or in their role as advocates in the community. Like, what advice would you have?
One advice I would have is to take a moment and think about how linguistic difference is related to race and racism. And so there's a really vast, interesting sociolinguistic literature that shows that someone's inability to understand a minority speaker is often due to their own biases and their own lack of familiarity, or their own preconceptions, or their own bias in thinking that the person is worth really listening to and trying to find out. So in other words, listeners are often not carrying their communicative burden, and minority speakers are. So that's something to think about. And then as lawyers, really keeping an ear out to object to this linguistic discrimination, to question whether or not someone's English language ability is clear enough, and so forth. And really to understand how, whether it's a 14th Amendment or a 6th Amendment claim could be articulated to prevent exclusion on the basis of race, ethnicity, or national origin, even though it's couched in language terms. So to start to get that sort of fluency, I think would be incredibly exciting for more members of the bar to engage in.
And I just want to pause and point out that your article on this topic could provide some of the supporting data for that kind of argument, because it includes some of the studies that show that people underestimate the English comprehension and overall intelligence based on their own limitations with accent. And so if you want to substantiate a claim like that, Professor Gonzalez-Rose's work, which we'll put in the chat at some point, would help with that. But turning that same question, your advice to the lawyers in the audience.
So I building really on what Professor Gonzalez-Rose said, and some of what you've said before, this is an interesting time in this country, and there is a lot of legislative work going on. There's rules work going on, and there are opportunities to participate as attorneys, as practicing defense lawyers in these committees. And I know they're not billable, and you can't, that's a hard use of time, but I have found that the diversity of participation in legislative working groups gives them strength and credibility and makes it possible to get work done. So I know of work happening, I don't know, I bet I could name 6 or 7 states where there are active task forces thinking about juries and how to do a better job at one or all aspects of juries. And getting involved in that, I think, is a great use of time and satisfying in a way.
And if you'll forgive me for getting into tomorrow's topic, but I do think it has relevance here. I think that I completely recognize that it's easy for me to say I am not a litigator, so I can say when you're in trial, you should do these things. I understand there's huge barriers to doing this, but to the extent Batson challenges are raised, I know they're very rarely successful, but if they're when lawyers have data from that jurisdiction on hand, again, all these things I recognize are much easier said than done. But to the extent you can actually proceed with a Batson challenge where you have, say, an analysis of this particular prosecutor's prior use of peremptory strikes, it has a chilling effect in a good way. In that when people are more accountable, right? When people are feel like they're accountable and they can't just get away with it, it might rein in some of the discriminatory practices. Again, this is just a piece of it. I recognize peremptories are actually a small part of the jury representation issue. But it's sort of my experience with this is anecdotal, but I do think that as uncomfortable as Batson challenges are to raise, and how hostile I think that the trial courts tend to be to them, I think they can sort of shape the culture of jury selection in a way that if I could figure out a way to study it, I might, but that would be my suggestion.
My advice to attorneys, especially criminal defense attorneys, is to maybe conceptualize the issue of folks with felony convictions being excluded as a reentry issue, as an inclusion access issue. I oftentimes hear folks on the defense side say, well, this will be better for me, right? Or on the civil side will be better for my damage awards. And the idea is that data doesn't bear that out one way or the other, right? Folks with convictions are not pro-defense, right? They are not overwhelmingly pro-defense. They are not going to hang every jury they're on. So if the goal here is to is to advantage your side, I'm not sure that this is going to do that, right? I look at this in a different way. I look at this as an access issue, as a reentry issue, as a reintegration issue, as bringing folks back into the civic fold that, as we know, right, service on a jury leads to additional possibly forms of civic participation and activism. So I look at it that way. And I think conceiving of it that way really get you around the argument that, well, you're just trying to stack your side, right? And I think that maybe has plagued some reform efforts with respect to re-including folks with felony convictions.
I don't know if this is permitted, but I can't help offering an idea that's coming up for me, hearing from you all, that I think my advice, this is raised by the point that Batson challenges and awareness of the use of peremptory strikes could help the judge see the Batson challenge that you're making in context. I would encourage attorneys to make the discovery requests pre-trial that are necessary to substantiate a fair cross-section claim, because many attorneys have the experience of walking into the courtroom, seeing an underrepresented group assembled there, and then it's really too late to get the information that we would need to make out a fair cross-section claim. So the points that people have raised before about the need for data and information, those are the kinds of things that could be requested by attorneys. And I see in the chat the names of a number of attorneys who I know have done that well and from whom I've learned a great deal about that process. My next question, because you mentioned some of the things that are happening now legislatively. And so I'm just wondering overall, there's reasons to feel optimistic about change. We are seeing some things. We have the lessons and energy and movement caused by the Black Lives Matter movement. And then there's plenty of reasons to feel pessimistic as well, the entrenchment of systemic racism and how everything moves slowly in the law. So I'm just curious, are you feeling more optimistic or pessimistic in this moment, and why?
I'll start, or I'm feeling more optimistic. California, again, passed SB 310 in January 19, took effect January 20, and was the first change to make juries more inclusive with respect to folks with a felony conviction in over a decade. Around the same time in 19, Louisiana tried, and as did New York. Both measures failed, but I believe there's going to be a redoubling of efforts in certain jurisdictions, New York, again in Louisiana, and possibly in New Jersey coming up here. So I'm excited. Part of the reason I'm optimistic is that I think that the sort of mobilization of the, decarceration and sort of the end of mass incarceration, I think is prompting other reforms that are sort of tangentially related. And I think this jury issue is related, right? And I think folks are in those groups looking at this as a reentry inclusivity issue and are approaching it that way. So the support then is sort of wrangled, right, for this. And so I'm very optimistic as to what I see happening. But again, cautiously so, right? Those carve-outs are many.
Yeah, I mean, I would concur with that. I am cautiously optimistic, assuming the entire society doesn't descend into fascism in the next few years, which I'm not 100% sure won't happen. But I say cautiously optimistic mostly because these of things like Washington's new rule on jury selection 37 and the California rule. That said, I feel like we're starting from a pretty low, right? Like there's really not much room to go but up. So that doesn't mean that I think we're going to have like any of these things are going to be a panacea, but they're a step in the right direction. I also do believe that sort of the popular culture, this is something that we think about all the time because it's our work, but I think it has become more prominent in popular culture. The Curtis Flowers case in Mississippi, again, I realize that case was about peremptory strikes, but that really did capture a lot of the public's imagination that, people were lined up around the block to watch the oral argument for the Supreme Court in his case. Just really opening, I think, people who don't live and breathe this stuff, their eyes to just how extreme and flagrant the discrimination can be and how the law is so poorly equipped to deal with it.
I think I'm not one to really think about optimism and pessimism. I'm always trying to get through the day, but I was thinking about my students. So I teach at Michigan State Law, and I think about the lessons. I teach the basic police investigation class, right? It's basic stuff, and 4th, 5th, and 6th Amendment. And we, of course, talk about the experience of being policed and how it falls unequally on the population. And I was struck this year by how much more knowledgeable, how much more vocabulary and understanding students across the room, all 80 of them, or maybe not all 80, but 70 of the 80 had about the depth of the problem, the strength of the issues that we're facing, the ways that race is important in our system, and it gave me hope. I think that the next generation is wise in ways that are so encouraging, and they've worked hard to find that. But I was so impressed by them. I didn't expect it. I mean, I've taught the same lesson for at least a decade, probably longer, and it was different. It was a different moment, and it was so exciting in a way.
One of the comments in the chat suggested, well, this is all very well, our efforts as attorneys around this, but what we really need is the involvement of judges and courts. And I think we have some judges, some court administrators in the audience. So what would your message to those people be? What can they do? Are we looking at legislative changes? Is it things that individual judges need to do differently when assessing for cause strikes? What are what are the changes that those players can make that you think would be most useful?
One thing I am struck by, a few years back, I had the opportunity to present some of this work on accent discrimination to about 100 state court judges. And the conversation afterwards went on for a long time. And what was so exciting was to hear about different approaches that judges took in their chambers. And these were very informal things, but how judges set the tone and how judges set the tone around linguistic inclusion and really seemed to influence the way that counsel that appeared before them practiced. And so I think I'm so happy that there are judges in this audience. I'm so happy to be speaking to so many judges who are interested in these issues. And I know they have tremendous, even in an informal of setting the tone and what they're going to tolerate. And I think it's really, really important.
In terms of the topic of, again, excluding folks with felony convictions, I think we are, looking for legislative changes first. I think once those happen, then there are concerns, right, at how judges look at for-cause challenges to folks with convictions. What are the questions? What are the things they're looking for? I think more of an individualized process is warranted with respect to folks with convictions. But at the first cut, I think it has to be legislative change.
Well, I'll just echo what, go ahead, Catherine. We may say the same thing. That we should keep records, right?
Well, and also look for opportunities to engage everyone in this conversation. So, Barb and I have had the rule for a while that we don't say no when a state jury commission wants to talk, we talk, and we don't change what we're saying, but we try to be heard. And I feel like the training and the conversations aren't perfect. They don't solve a lot, but at least they begin to open the conversation. At least the idea that they can, I don't know, maybe they don't do any good, but it seems to me like there are more conversations to have. And so maybe I think about a judge a long time ago watching evidence that in fact in his court, the race had been important in the selection of juries. And thinking of, and it brought tears to his eyes, right? This wasn't this was huge. And I think he would have welcomed a better understanding earlier. And so I guess I feel like we all have things to learn and got to keep figuring out how to do the teaching.
One thing that was just making me think about, I want to lift up an article by Sonali Chakrabarty, who's a professor at Wesleyan, that was in the Atlantic about the oversight of the for-cause strikes by the judge in Derek Chauvin's trial for the murder of George Floyd, and how the judge's role in setting the tone and the kinds of things that counted for that judge as biasing or not biasing were sort of a model that we could move forward. So I recommend that article. One thing, James, you made the point earlier that it's one thing, we need legislative changes, but in addition to making the legislative change, we also have to get the information out there so people know about it. And so thinking about that question, for jury reform, both what are the small fixes, like the admin things that could actually make a difference, and what are the big radical overhauls? Like, I'd be interested to hear from you. What's the small fix we'd be surprised to know could make a difference? And what's the radical overhaul that might not be next up on the agenda, but would be necessary?
So I think in terms of notification, what we know on the voting side is that when folks have been restored, the cleanest, clearest way, right, to inform them is to provide them with documentation, and research shows written in clear, concise language, short language, right, that isn't part of larger, right, paperwork packets that they get, from parole or from their supervising agent when they're first home. I think the radical change would be to charge supervising agents or the DOC with, ensuring that folks are back on the jury rolls and back on the voter rolls prior to, as part of the release process, right? I'm not sure that's ever going to happen, right? But I think that the easy quick fix is just notifying them in a way that is digestible and that isn't part of sort of larger restoration stuff. The radical fix, I think would be charging the folks who locked them up to actually help them with ensuring that they were eligible on both fronts.
I just have to note that if I'm not mistaken, the Genesee County Jail, when I was there recently, had voter registration happening.
Other panelists want to speak to either the small fixes or the big overhaul change you'd like to see?
Well, I was going to say one other thing that's just like what Professor Bernal said, and that is texting. Texting reminders, saying to people, hey, jury duty's tomorrow, helps.
For me, it would be thinking about, I don't like English language juror requirements, but a small step would be to not include requirements that people read and write in English, because often those skills are not called upon in jury service, and disproportionately exclude certain people, usually people of color. And of course, it's people of color. I talked a little bit, kind of emphasized the Latino, Latinx group, but it's other groups as well, groups that are perceived to be foreign, Asian, American, people, African descent, and so forth. It's a big group. The big change, so standardizing that to be less burdensome, and the big change would be allowing juror language accommodation. So that would have inclusion, and so people would not be excluded on the basis that they're bilingual or multilingual or have a perceived accent. And also being limited English proficient.
Just looking at the chat again, I don't want to miss any of the questions, although people are making a lot of observations too that are useful. I guess maybe my last question, though I'll leave room for some more attendee questions, is just for each of you, what's next in terms of your own scholarship or your activism? What are the next topics, approaches that you plan to tackle? Because all of your work has been illuminating and helpful, and so we're curious to know what will be next.
For me, where I'm really excited is, in addition to being a law professor at Boston University, I'm the Deputy Director of Research and Policy at the BU Center for Anti-Racist Research. And I'm so excited about, one, working with communities and getting community input more. Two, creating tangible policy products. And so, for instance, I've started a model legislation unit, and just start taking some of these ideas that are in the abstract and start putting them to be something that could be adopted and explored, and being sure that that's community informed.
I'm working on a few projects ongoing. The two that I'm most interested in and most proud of are, so we're doing an implementation study in California to see sort of how does this work on the ground, right? I mean, we are now eligible, quote unquote, folks with convictions are, but are they getting on juries? Are they being dismissed? What does this look like? The second project that is really interesting is really digging into this idea of the skills and attributes that folks with, and really the knowledge that folks with convictions bring to the jury process. What are those skills? Are they sort of subject matter experts in a criminal trial? So digging into that and sort of seeing, are there additional sort of skills and attributes that maybe were missed in the mock jury experiment, and what we can find there.
So I think it's hard to think ahead. We're still actively involved in litigation in North Carolina under the Racial Justice Act, and showing how the role of race in the exercise of peremptory strikes and capital jury selection. I think and Catherine can certainly chime in and add or detract from this, but we started, we had a grant several years ago, and we have a couple of papers out of it looking at the actual conversations that happen in voir dire, and sort of this idea of stereotype maintenance, and really systematically studying the way that the discourse unfolds in voir dire, and the extent to which that sort of paths that begin early that lead to an excusal, either for cause or as a peremptory strike, and how the questions that get asked and the follow-ups that get asked can really shape that process and exacerbate disparities.
I think I would only add to that so some of our recent work has been looking more closely at the exercise, the use of cause strikes. And I think that's a under studied area in jury selection, and one that I think it would be a good idea to have us all understand better how cause operates.
Well, this is a little unconventional, but I'd like to close with a question for the attendees, because one of the great things about the chat is people have been posting in different resources, some by our speakers, some that folks are bringing to the table. And as noted, all of those will be available. The links will be available with the recording of this. So if I might ask attendees, if you could type into the chat, what is the resource that you or lawyers in your office could benefit from the most? Is it research on a certain topic? Is it a best practices for a certain thing? Is it Batson specific? Is it about fair cross section? Is it about language, felony convictions? And again, it doesn't have to be something you need, but because those are the kinds of resources that as part of this project, we could track down and make more available. Okay, best practices in challenging fair cross section, on it. All of the above. That's not fair. Batson, great. Please keep adding these, because a lot of this material exists and we can share it, and some of it needs to be researched and created, and that would be a wonderful space to move into. I realize now you're just watching me read the chat. I will wait and read it later, but please keep adding. Get you into that space as well.
I just want to say how grateful I am to the amazing work that people in the audience are doing, that I can, you know, people were saying the work that they were doing at the beginning as introductions, and then the insights, and just doing this work, and you're an inspiration, and thank you for all that you do. And I'm just so inspired.
This is my question that I ask in these jury series is, has anyone served on a jury? Nope. That's usually.
No, but my
I've been
husband
on a
is
jury.
Oh,
I wasn't allowed till 2020, but I'm looking forward to it. So.
I was on a jury in Washington, D.C., which anyone listening will be like, yeah, you were in D.C. Everyone's on juries in D.C. It was a dropsy case, and we did not convict.
and my husband got called for jury duty this week, and he keeps having to call in, and he's so happy when they don't need him. And I want to go to jury duty so bad. I want to serve in a jury so bad.
This I think it was, and I didn't get picked. I was very upset. So we're probably a few groups of people that have this extreme interest in juries and want to be on to serve.
Yeah, Monica and I have a theory that our passion for being on a jury is what's thwarting the arrival of the summons. But I do think one of the things that was highlighted in the comments that's important is, so most of us groan, okay, maybe not the people at the seminar, but most people groan when they get the jury summons and they still serve. And so I think the message is not that we need to tell people in the community about how important it is to be on juries, but we need to create changes in the laws and policies to allow people to serve on juries, because for all the groaning, people do show up when they're given the opportunity. And as you pointed out at the beginning, we're all better off when that happens. We have higher quality deliberations and judgments that better reflect the community, which is the purpose of the jury, and that better reflect the community, which is the purpose of the jury in the first place.